take it under advisement. We now turn to 126225, State of Kansas versus Gomez. Counsel.
May it please the court, Emily Brandt on behalf of Patricio Gomez. I plan to focus my remarks today just on issue 1, the sufficiency of the evidence supporting the alternative means charged by the state to support a felony murder conviction. Patricio is ultimately asking this court to vacate his conviction for felony murder. I'll start with the attempted distribution of methamphetamine as an alternative means to commit felony murder here. The state was required to prove that Patricio killed Martinez during the attempted distribution of methamphetamine. It's Patricio's contention today that he completed the crime of distribution. Patricio went to the hotel room that day to sell methamphetamine. Methamphetamine was weighed out. Methamphetamine was found in the hotel room. KBI lab analysts testified that it was in fact methamphetamine. There was testimony that the decedent Martinez was trying to find a container to put the methamphetamine in. And today we're asking the court to reject the state's argument that the statutory definition of distribute is irrelevant, as it merely describes the factual circumstances under which the material element of distribution may be proven. Here, distribute is defined as in the statute and was provided in the jury instructions that distribute means the actual constructive or attempted transfer of an item from one person to another. If an attempted transfer of an item from one person to another is a factual scenario in which distribution can be completed, and that factual scenario is present here, Patricio was trying to transfer this methamphetamine to the decedent Martinez, then we have sufficient evidence that he actually completed the crime of distribution of methamphetamine. The state has relied on State v. Castleberry, 301 Can 170, to argue that that the state didn't need to prove this factual scenario, this attempt to transfer, in order to prove that an attempted distribution of methamphetamine occurred. Patricio would agree with that. Castleberry, we're looking at something totally different here. This was a challenge to the jury instructions. Castleberry had conceded that there was sufficient evidence of both actual and constructive transfer of methamphetamine, but was trying to argue that the actual, constructive, and attempted transfer of methamphetamine all created alternative means by which to commit the crime of distribution of meth. So there needed to be sufficient evidence of all three of those means in order to convict him of distribution of methamphetamine. Patricio's not making that argument. He's not arguing that those three factual scenarios are alternative means. He's arguing that one of those factual scenarios, an attempt to transfer methamphetamine, occurred here. And because that factual scenario is present, there's sufficient evidence to prove that Patricio Gomez committed the completed crime of distribution of methamphetamine.
Is it fair to say that your argument is that attempted distribution is an impossible crime in Kansas?
I think that that would be an accurate depiction of my argument, Your Honor, because we have chosen to define distribute to include an attempt to transfer. If you attempt to transfer, you've completed the material element of distribution. And it was the state's choice to charge this as an attempted distribution of methamphetamine, and it's our contention that they failed to do that. We would next ask the court to reject the state's argument that attempt to commit here has some unique meaning in felony murder land, as applied here to Patricio Gomez. Even if we accept the premise that attempt to commit does have a special meaning within felony murder land, here the state didn't choose to instruct upon or charge upon distribution of methamphetamine. And that during the res gesta of trying to complete that crime, the decedent Martinez was killed. they chose to charge attempted distribution of methamphetamine. I don't know if that puts us into sort of an attempt land, where you are saying that it happened both in the attempt to commit attempted distribution of methamphetamine. But certainly we would argue that claiming res gesta doesn't get us out of the problem that we have a completed distribution of methamphetamine. And the state chose to charge as the inherently underlying dangerous felony attempted distribution of methamphetamine. Moving to the attempted aggravated robbery, I would simply ask this court that the record bears no support for this means. This was a drug transaction that ended incredibly tragically, but Patricio wanted to sell methamphetamine. He was there to sell methamphetamine. All of the testimony supports that during this transaction, the decedent Martinez ended up dead over the inability to pay via an electronic payment. So and I think that the jury saw this. They acquitted him of the attempted aggravated robbery. So we would ask this court to find that there's insufficient evidence of both underlying means here. And because there's insufficient evidence of both underlying means, we can't have a felony murder conviction. And so that conviction needs to be vacated. In the alternative, I will just mention as a final point that if this court finds sufficient evidence of one of the means, Patricio is respectfully asking that this court not follow the new rule of law pronounced in Reynolds, because one, it is a new rule of law, and two, it creates a substantial hardship and prejudice to Patricio because at the time he was tried, there was no burden on him to preserve an alternative means argument for this court's review by objecting to the instructions, since it was just a sufficiency standard at the time of his trial. So we'd ask that if this court gets into alternative means land, that they still reverse for a new trial on the means.
I guess the difference I've got with you on this one, setting aside even the alternative means stuff, the whole purpose of this alternative means error theory is the confusion of the jury as to which, and not being able to tell once you get a conviction what it's based on. And it might be based on something where there's insufficient evidence. But we have a jury verdict form in this case, and the jury specifically found him not guilty of attempt to commit an aggravated robbery. There's no confusion what the jury found. So what's the point?
Well, respectfully, Your Honor, this court has a long line of cases where it has held that inconsistent verdicts in felony murder land are perfectly fine.
How is this inconsistent? Okay, it got pled. The jury came back, looked at the evidence and said, no attempting to commit aggravated robbery. There's no confusion, right? We know what the jury found. They found him guilty of attempting to distribute. You can argue the sufficiency of that all day. That's fine. I get that. I don't see why you get to use the alternative means theory when you have a specific verdict form that tells us what the jury found. You see what the point I'm making?
I understand your point, Your Honor, but again, this court has previously held that a jury can both acquit of the alternative means, and there can be sufficient evidence of that means to support the felony murder conviction. So I guess in my view, again, my argument today is that there is insufficient evidence of both of the means, but that if you find sufficient evidence of both means, that then we don't know which one the jury relied on to support the felony murder conviction. I mean, we know that they found him not guilty of the attempted aggravated robbery on its own, but this court has held that every single charge in an indictment or an information or a complaint, they are separate and distinct from one another. So we know that they didn't find him guilty of attempted aggravated robbery as a standalone offense, but we don't actually know what the jury decided when they went back there as to the felony murder.
Do we even need to get to alternative means? Because it seems to me that if you lose your sufficiency challenges, you lose the alternative means argument because there's sufficient evidence of both theories. But if there's insufficient evidence, there's insufficient evidence. So isn't it all turn on the sufficiency of the evidence at the end of the day?
Yeah, alternative means was always my alternative argument. Okay. So yeah, if you find that there's insufficient evidence of both means, Patricio and I would greatly appreciate if you didn't get to the alternative means argument. But if you find there is sufficient evidence of both means, then I think we still have an alternative means problem because, or if you find that there's insufficient evidence of one of the means, but sufficient evidence of the other means, then we have an alternative means problem. And again, that would be under State v. Wright and not the new law under State v. Reynolds, in which neither of us have.
That's not necessarily true, though. If the jury find, well, you haven't proved beyond a reasonable doubt all of the elements of aggravated robbery, because we don't believe certain things and we believe other things. That's different than a sufficiency examination. So you can have both, right?
Yes, you can have both. You can have both, Your Honor. I'm sorry if I misspoke. You can certainly have, again, this court has held that it's fine to have inconsistent verdicts in felony murder land. It is fine for the jury to acquit on the standalone charge of attempted aggravated robbery, but also fine for there to be sufficient evidence of that means to support felony murder. And so it is okay for those verdicts to be inconsistent. So my argument today is that, one, there's insufficient evidence of either means, so the entire conviction of felony murder has to be vacated and he can't be retried. But in the alternative, if this court finds that there's sufficient evidence of at least one of the means, but insufficient evidence of the other means, then we have an alternative means problem because they need sufficient evidence of both means.
Okay, so let me ask you a question. If there's, let's say hypothetically, we find sufficient evidence of both means. I want to be able to understand your argument about Reynolds and Wright. Are you saying that, that because your client, when it goes to reversibility, you know, viewed in the light most favorable to the state, the evidence shows beyond a reasonable doubt. You're saying that it has to go back because he didn't know that he should object. Is that? Because now we're looking at sufficiency of the evidence under
Yes.
Reynolds.
Yes.
If we do the Reynolds, well, I know, let's pretend.
Well, under Reynolds, we'd be doing instructional error.
Okay, right. So I guess I'll break it down a little bit
Okay.
further. If it's instructional error, you look at whether it was legally sufficient.
Right.
And your position is it wasn't factually, right?
Right. Yeah.
Okay.
Yes.
So let's say that we're not convinced by that and that it's factually sufficient on both means. Then you go to reversibility and your client didn't object.
Correct. So we'd go to clear error.
So it would go to clear error and so are you conceding that you would just lose on that or what if that, take me down that road?
Well, I haven't briefed it. So if this court is interested in us briefing the Reynolds issue, I would appreciate an opportunity to supplementally brief that. But I mean, I think in this world of felony murder, if you find that both of these means were factually sufficient, I'm not sure standing here without supplemental briefing how we could see that they are legally insufficient, since the felony murder statute clearly delineates that both distribution of methamphetamine and aggravated robbery are inherently dangerous felonies that can be charged to support a felony murder conviction.
So it's legal, so you would say it's legally appropriate, right? Or not? You don't want-
Tentatively, without briefing it, I think that I would.
Right.
That's where I think it would lead us to. But Patricio was never, he was never given the opportunity to object in this way because he didn't know that he had this burden to object. Because prior to Reynolds, he could get the super sufficiency alternative means standard, which doesn't require any objection for preservation purposes.
But you would still lose under that framework if there's sufficient evidence supporting both inherently dangerous felonies.
That's correct. Under Wright, if there's sufficient evidence of both alternative means, then Patricio loses. So our primary argument, again, is that there's insufficient evidence of both means because we have a completed distribution of methamphetamine and no evidence of attempted aggravated robbery. So, yeah. Unless this court has any other questions, I will save the remainder of my time for rebuttal. Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. The defendant reached out to his friend Shay Roberts to see if anyone needed work, a code word for methamphetamine. They got together, and shortly thereafter, it just so happened that Michael Martinez sent a text message to who he thought was also his friend, Miss Roberts, and seeking work, methamphetamine. He wanted specifically 1.75 grams. The group of defendant and Roberts head over to the hotel to meet Martinez and his girlfriend. Girlfriend, Miss Hampton, lets them inside. They go upstairs. Roberts starts weighing out the methamphetamine. Defendant confirmed that it wasn't too much or too little, and then everything else went back into the purse. At that point, the victim in this case, Mr. Martinez, struggled to pay. He couldn't get Cash App to work. He started looking for a container while the defendant's friend Roberts, their mutual friend Roberts, used a printer. Ultimately, Hampton comes out. She tries to get Cash App to work. Doesn't work. The methamphetamine remains on the scale at that point. And I think that's the thrust of the state's argument as far as the sufficiency of the evidence, is that there's actually no evidence in this case of an attempted transfer of methamphetamine. There is evidence of an attempted distribution, and I'll get to that. As the Cash App program continues to fail, the defendant eventually pulls a handgun, and things get weird pretty fast based on the history of these individuals. There are accusations of extortion for clothing, accusations of extortion for personal identification information for identity theft purposes. There's a demand for profiles, demands for clothing. As Ms. Martinez began to comply, there's usage of a phone. The defendant takes the phone away from Ms. Hampton and throws it on the table. Ultimately, there's also argument about gang affiliation. The defendant even took a picture of his victim, Miss Martinez, and the young woman, Miss Hampton, that was there with him, tried to send it to someone, and ultimately, the defendant turns to Miss Hampton and says, "I'm sorry, you're just at the wrong place at the wrong time." Again, while he has the gun out, pointing the gun. And at that point, the victim, Mr. Martinez, rushed the defendant, and they struggled until the defendant fired 3 times, striking Mr. Martinez once. Mr. Martinez continued to struggle. Then he realized he was shot. He ran and hid in the closet. The defendant and Ms. Roberts then flee. Victim, Mr. Martinez, comes out, slams the door, and there is a 911 call. He wasn't the only 911 call. Didn't come from that room. There were other hotel guests. Hotel staff got up there. They got Miss Hampton out. Left behind were 6 methamphetamine crystals weighing approximately 1 gram. They were mostly on a nightstand between the bed and a closet, and there was 1 methamphetamine crystal on an ironing board. So what we have in this case, the state maintains, is that there was sufficient evidence of both alternative means of felony murder. And to be clear, the alternative means of felony murder were distribution of methamphetamine and aggravated robbery. What we had here
They were attempted, right?
It was attempted.
Attempted for both of those, right?
You said evidence
Yeah.
distribution.
Right, excuse me, yeah. We alleged the attempted distribution of methamphetamine. And so what we ended up ultimately having is that the state believes that there was sufficient evidence of an attempted distribution, but there was no evidence of an attempted transfer. And that is a subtle but very critical distinction, because what defendant seizes on in this case in attempting to found his argument is what is a description of factual scenarios used as examples to try to highlight and define the word distribute. not all of those have to be present in any single case. In fact, only one needs to be. There may even be something else that reasonable jurors could agree, or that would be evidence of distribution. And that's the key. Attempted distribution isn't an impossible crime because the key here is transfer. And it is indeed possible, as this case evidences, to attempt to distribute methamphetamine without ever actually trying to transfer it from one person to another. In fact, all of the evidence here indicates quite clearly that the defendant had no intention of transferring any methamphetamine until payment came through, and that was going to come through either via cash or ultimately, as things devolved over time, it was going to rob them. I think the Castleberry case is a critical one here, for a couple of reasons. Again, it highlights the fact that about the alternative means. We would just ask that this court follow the state's analysis of Castleberry and its usage here, and then move forward on to the sufficiency of the evidence. And ultimately what it comes down to is a situation where we have a defendant that wants this court to reweigh the evidence. The jury weighed this evidence. As Justice Biles pointed out, they clearly weighed the evidence. They didn't convict of everything. Now that may be the only point that I would agree with opposing counsel today, is that I don't know that that means we're in a full-on Reynolds situation. Because in felony murder, you can have inconsistent verdicts. It is possible here that there were 11 jurors that felt that both were present, and one juror felt that there wasn't sufficient evidence of an attempted aggravated robbery. But ultimately, that doesn't matter for felony murder purposes.
Before you get fully into super sufficiency, sort of right,
Sure.
Reynolds land, and I'm sorry to make you do this. I'm struggling with this notion that attempted distribution is an impossible crime. And I want you to walk me through it. I know you just covered it, but
It's all right.
you said it's not an impossible crime. And of course, I understand that is the state's position since that's what was charged, but
Sure.
help me understand that. And I do have the language in front of me.
And that's what if you give me just a moment, I'm going to try to get to that language here.
And as you're looking, my sort of underlying question or follow-up would be, are there any appellate cases, Court of Appeals or from our court, that talk about this question, this statutory anomaly of having the word attempt in the actual crime itself?
I think the closest that we probably come is Castleberry, and the fact that it's very clear that what these things are not elements. They're factual scenarios that can help illustrate what it means to distribute something. And the definition of distribute, and it was given here, is the actual constructive or attempted transfer from one person to another of some item, whether or not there is an agency relationship. And then it goes on to include that distribute includes, but is not limited to, the sale, offer for sale, or any act that causes some item to be transferred from one person to another.
And you're reading from the statute.
Exactly.
Correct? And then that language is essentially word for word repeated in the instruction.
Correct. And I guess the only other thing that I would note on that is that
But if that's a definition, I mean, we're talking about transfer,
Mhm.
and it says attempted transfer is distribution.
correct. The attempt to transfer is
Is there any other way to distribute other than transfer?
yes, the actual or constructive
But that's still transfer.
that would be a transfer. That, I think that's where that's the nub
But
that
in
I'm
it-
trying to get at.
But they're all like this. The definition makes them all interchangeable and completely identical.
They are not identical. They are
Well, they're not
equivalent.
factually identical, but legally they're equivalent.
They are
So an
legally
attempted transfer is legally equivalent to an actual transfer.
they are legally equivalent descriptions of facts that could support a distribution. is the best way I can answer your question based on this court's case.
Is what you're saying that in fact, the exact same facts would support a conviction for both attempted distribution and distribution itself? I mean,
I don't think-
your opposing counsel's argument is predicated on the idea that a defendant cannot be convicted on the same facts of both an attempt and a completed crime.
Right, and I don't think,
You
think
agree with
they-
that?
I don't think that they could be convicted of both either.
Okay.
I think that what we're talking about here, again, the element itself, and I do wish it was a little more clear, but based on this court's case law, the element is transfer. And then we're tasked with the question of, well, what kind of things can the jury look at to evidence that a distribution has occurred? Well, you can consider the actual transfer, or if something's given over, then it has been distributed. Constructive transfer. I think I have at least one example of that in my brief, and we get close to that here in the defendant gave the drugs to somebody else to potentially give to get a third party. And then you have an attempted transfer, which would be the actual act of trying to hand over the drugs. And that's the missing evidence here. There's no evidence that the defendant or his co-conspirator ever tried to deliver the methamphetamine by handing it over to another person. The closest it came was that the victim looked for a container.
So
because he never did get it.
is it correct to say then that the crime of attempted distribution is effectively an attempt to transfer?
That one.
That sounds like what you're saying.
That one I think would be resolved because in my mind, that would be a factual impossibility.
Okay.
And I think that's how we resolve it ultimately, is that these are fact patterns and that scenario is a factual impossibility.
Okay.
Ultimately, the state believes that there was a super sufficiency of the evidence demonstrated in the instant case because this was a meeting to distribute drugs, but there was never any actual attempted transfer. What we had here was an attempted actual or attempted constructive sale that just never was completed because things fell apart and the defendant got upset and he killed someone because of it. We would also ask that this court upholds on the super sufficiency basis of the attempted aggravated robbery, because in his fury, the defendant clearly started demanding things and the victim in this case actually even started to comply. Ultimately, the victim or the defendant and his co-conspirator, there's no evidence that they actually got away with anything. In fact, they left a shoe behind. They fled so quickly. They left their meth behind, or at least most of it, as they fled so quickly. And so ultimately we believe that the super sufficiency of the evidence was satisfied in the instant case. If there were any interest in additional briefing following Reynolds, again, based on the super sufficiency, we don't believe it's necessary. And would ask the court to uphold as it is currently briefed. Very, very briefly, in my issue B, like 1B, I discussed that attempt has to mean something a little bit different in the felony murder context. I think that's pretty plain on its face, because an attempt to be convicted of an attempt crime, you have to have failed to complete the crime. In felony murder, a killing can occur during an attempt, and that's the point of the res gesta element. And my argument in that regard is that simple. And I think that's what all of the cases that I cite in that section emphasize. I also think that that's what we have here is very similar factual scenarios to those cases. If there are no other questions, the state is aware that there is one sentencing error that has to be addressed here, but we would ask that the defendant's convictions be upheld. Thank you.
I guess just briefly, again, going back to this res gestae where attempt must mean something different in felony murder land. My colleague has said it's a factual impossibility for there to be an attempt within an attempt. And I think if you include the attempt of the res gestae of felony murder, we're now 3 layers deep into attempt here. We have an attempt to transfer and an attempted distribution of methamphetamine that the attempt occurred during the res gestae of a murder. So if you get 2 layers of attempt and that's factually impossible, I don't know how we get the 3 layers of attempt and that's fine. I think it's very clear here that Patricio did try to transfer drugs.
If we just look at the raw elements in the statute, and I guess leave logic aside, why couldn't a person be guilty of both attempted distribution and distribution under the elements?
Right, because I think an attempted distribution is a completed distribution.
And that's the logic part of it, and I get that, but I want us to focus, it's at least for the purposes of my question,
Okay,
just on the elements. Because, I mean, I think there's, the argument has at least some resonance that you're making, that the elements of the completed crime incorporate an intent. But if we look at the elements of, attempt, that also is met, right? Aren't both crimes essentially met under the facts?
well, an attempt requires the failure to complete the crime. And because my argument is that we've completed the crime, I don't know how you can fail to complete the crime to support an attempt.
So failure is, your argument would be that failure is effectively an element of attempt.
Yes, you have to fail to complete the underlying crime. Otherwise, you've completed the crime.
Okay.
You haven't attempted it.
So your argument is that even within the elements, the law precludes that as a possibility.
Yeah, that
Okay.
would be correct, Your Honor. And so again, Patricio's argument here is there's insufficient evidence of both means to support felony murder here. There's insufficient evidence of an attempted distribution of methamphetamine. And as the jury found, and as I think the record is clear here, there was no attempted aggravated robbery. And without sufficient evidence of either of those means, Patricio's felony murder conviction must be vacated and he cannot be retried. And so that would be our request today, is that you vacate his convictions for felony murder and attempted distribution of methamphetamine. And in that case, you won't need to remand for resentencing. So I appreciate the court's time unless you all have any more questions. Right. Thank you.
Thank you. We thank both counsel for your arguments today. The court is now in recess until 9 a.m. tomorrow.